Good evening and welcome to Town Hall Talk. The elections that began on the 7th of December 2020 effectively ended yesterday for the NDC. In a repeat with the tables turned of what happened in 2012, the losing candidate, or the candidate that has been declared to be the loser, sued the candidate that had been declared to be the winner. The court delivered a verdict yesterday and indicated that the petition had been dismissed. Tonight on the show, I have a well-known face of the NDC, someone whom I've always indicated I've been proud to have known him many years ago since our school days. The Honorable Inusa Fuseni, the Member of Parliament for Tamale Central. He speaks widely on many issues that I share perspectives on, and I'm always happy and delighted to have him on this show. This is not the first time he's here, and I welcome him with delight. Honorable Fuseni, you're welcome.
Thank you, Dean, and it's a pleasure to always be with you and to talk to you.
So I would be grateful if you can approach the microphone a bit. Excellent. So as I indicated, effectively it appears things have ended electorally for the 2020-2024 period for the NDC. Were you satisfied with the outcome of proceedings? Obviously, you lost, so I'm not sure you're satisfied, but were you satisfied with the verdict generally?
Thank you so very much. I think that you are well aware that in this adversarial system of court justice that we have, the loser is never satisfied. I mean, the loser has always grievances against the court. I mean, no adversarial system produces a loser who says that, well, I'm satisfied that I've lost because the court dispense justice in the matter. So yes, so we obviously are not satisfied. We have reasons to believe that in the pursuit of justice, certain things were overlooked. We have also reasons to believe that there was the obscene attachment to the concept of rule by law instead of the rule of law. And that deprived us and the people of Ghana of the benefit of appreciating the entire nature of the case that we sent to court.
The court is a court of law. What is your grievance about its attachment to the rule by law, to use your expression?
Well, the rule by law doesn't always produce the justice, the outcomes that one wants and pursues when he goes to court. I mean, the reasons why people go to court is justice. And when there is an obstinate attachment to the laws, the rule of law, the rule by law, then it becomes almost well nigh impossible for the courts and the judges to exercise discretions that will allow for the pursuit of justice to manifestly done. And that is the problem.
I'm sure you're speaking to the many applications that you brought, which the court obviously dismissed. So let's unpack them. The first one, at least in no particular order, but the first one, the issue with interrogatories. The court dismissed that with an assigned reason, and the reason is the questions that you seek answers for in the interrogatories could come at the trial for which responses can be given to, and in respect of its case management responsibility to ensure that decisions are given, that the whole proceeding takes place within the statutory period of time so they don't go beyond, given experience of 2012. In terms of that responsibility, they would have to manage the time. And so that's why they dismissed, for example, the request for interrogatories. Do you have any particular concern with that?
I do not, I can't fault them on the reasons why they thought, and rightly so, that the questions that were being asked in the interrogatories could be asked
at the trial.
At the trial, and could be put specifically to the witness of the first respondent in cross-examination. That makes sense, even though the reason why the Petitioners' Council went to court with that process was to try to expedite the matter. So there was mutuality here. Whereas the court was looking to expedite the trial and ensure that they complete the process within the time allocated, the petitioners' lawyers were also trying to help the court the process. By filing the process, we could expedite the trial. And so there is no...
So did you fail in that respect, therefore, to convince the court or communicate that, look, we had a mutuality of interest, like you said? Because clearly the way the court spoke, the impression one gets is that the court is in favor of expedited trial, yes. And the petitioner's move was against expedited trial. So there wasn't a sense of mutuality, at least from the perspective of the court.
Dean, you and I know that the purpose of that process in the trial is to ensure that certain matters which could come up in trial or in cross-examination would be admitted, and then that is dealt with. And that only serves to expedite the trial process. It serves to cut short time which would have been wasted in putting to the witness in cross-examination matters that have already been admitted and are in evidence. And so that mutuality could not have been lost on the court.
Why do you think the courts misunderstood you?
Well,
if you appear to have the same mutuality, why do you think it is? That
even the devil has no capacity of knowing what is in the minds of the judges, let alone humans like myself. I would not know exactly what agitated the minds of the court.
Could it be the way you articulated your position as a party, not as a political party, I mean as a party in the case? Could it be the way you articulated your position so that it wasn't well understood?
Also, in the way Carl Lewin said, that the idiosyncrasies of the court is the law. And probably they felt that, well, in their opinion, matters of this nature should not be introduced to delay the process. Probably that was their thinking. And that is the law. That is for that, and they ruled on that. And that effectively closed the door to the petitioner. And so the idiosyncrasies of the court, the judge, in this case, determined that that process was intended to delay the process.
If you take the second one as we unpack, again in no particular order, but the second one dealing with the attempt to get the second respondent, the Electoral Commission, to testify, even though it had clearly indicated, or the chairperson, the counsel for the commission and the chairperson has clearly indicated that they were not intent on leading evidence. Why do you have a case with this? Because again, the court clearly rationalized that. And the rationalization is, it is a time-tested principle in our jurisprudence that a person cannot be forced to testify. In fact, in the worst-case scenario, the Constitution is against self-incrimination. So a party has the right to elect, to decide whether or not to speak in a trial.
The Constitution is against self-incrimination, and it's a time-tested and honored principle in law that you can't force a person to give incriminating evidence against himself. But that's in a criminal trial. That's not in a civil trial. Now, again...
The rights, sorry to cut you, but the rights not to incriminate, I mean, the rights not to refuse to give evidence.
The right not to give evidence.
That's also allowed in civil trial.
That's allowed in civil.
Correct.
Yes, not to give evidence. That's allowed in civil.
Correct.
Now, but what I'm saying is that election petitions are in the broad categorization of suits, a civil suit. Because, broadly speaking, they are civil and criminal. And Article 88 is quite clear in civil and criminal. Even though we have matrimonial causes and others which are civil and criminal. I mean, they are between people. Now, so election matters can be classified as a civil trial because not criminal. That being the case, one cannot fault judges if they employ principles in civil jurisprudence to determine matters in election process. And you can see clearly some of the authorities they cited had nothing to do with elections. They were just principles enunciated in a civil trial. But you agree with me that election matters or an election petition is sui generis. It is in a class of its own. That is why the Constitution, even though it says that criminal or civil trials shall be initiated on behalf of the government at the behest of the Attorney General, the Constitution provides a procedure for election petitions.
But those can be adapted. I mean, I hear
you. I agree with you. They can be adapted.
Correct.
Because in the first place, we don't have the precedents, the body of law, decisions of court in election petitions to draw from. Most of the principles in civil law will have to be adapted.
But
the situation.
The fundamental point, though, is aren't the principles the same? I.e., getting a party on the stand to testify when that party says, I do not want to speak, I do not want to testify, and I leave the courts to draw whatever inferences they want to draw, but I do not want to testify. Isn't that fundamental principle applicable, whether it is constitutional cases, regular civil cases, criminal cases, petitions in divorce matters, whatever it is? Don't we have that principle cutting across?
Well, so why do we go to court in an election matter? Is it to vindicate a private right? It's an election petition, not of significant national importance, such that the search for justice in an election petition must not draw inferences or allow the courts to apply principles of civil procedure to an election petition as if an election petition were a process which seeks to vindicate a private right. Because there's public rights here. There's the interest of the public that ought to be acknowledged at any time an election petition is before the courts. Mind you, more than 6 million people voted for the petitioner. And so their interest, the interest of the 6 million people who exercise their franchise in favor of the petitioner are coterminous with the interest of the petitioner. And so you must look at the larger public interest in an election petition than simply relying on time-tested civil principles in civil law to determine the matter. You must, in the search for justice, in a civil matter, one must ensure that the rights of the parties or a party is not had done by. I mean, you have to acknowledge and vindicate the rights of a party in the civil procedure to be seen to be doing justice. If the facts or the evidence produced support that right, the vindication of that right. In the election matter, it's more than that.
But mustn't the interest and the rights of the Electoral Commission, or rather the interest and the rights of the petitioner, be counterbalanced by the rights of the Electoral Commission? And I say this, asking you, for example, that must the EC Commissioner, or indeed the EC, be always forced to testify in an election petition in which there is no requirement of threshold, in which there are no standard heightened review of admissibility, in which the court doesn't have a system of sifting cases for the court to decide we are hearing this case or we are not hearing that case? Because of the standard character of the Constitution, every electoral petition by a losing candidate, the court must look into it. No. Do you think that the court should open this floodgate of compelling the Electoral Commission to, in each case, come and account for all kinds of things? Or you think that the court should do what it's done, i.e., if it's convinced that there's no basis of calling the Electoral Commission because, frankly, it's going to be a pest on her, the commissioner shouldn't be called?
Well, first of all, I do not think that the jurisdiction of the Supreme Court in an election matter can be invoked by frivolous applications. And the Supreme Court has said that many times.
But there are no safety mechanisms. I mean, unlike other...
So they determine whether the application is frivolous or not. And so, and they have ruled on certain applications which are frivolous and vexatious. So that is a settled principle which is applied by the Supreme Court in sifting cases. So, yes, they have a mechanism to do that. I mean, if a petition doesn't disclose a reasonable course of action, or in the words of a man in the street, if there are no triable issues in the petition, the Supreme Court's jurisdiction cannot be invoked. And the Supreme Court will say that it will not sit on such a case because they see no issues to be tried. Now, you talk of rights of the Electoral Commission and the Electoral Commissioner. Again, that's a fallacy. The Electoral Commission is a constitutional creation. It's a public office. Exists to serve the public. And anybody who elects to be an electoral commissioner becomes a public servant. So you must at all times be aware that the interest of the public is more weightier than his or her own personal idiosyncratic interests. You must subsume, like in Anania Fiajo. You must subsume your private interests to the interests of the state if you are a public servant. And so you cannot seek to say that because I'm an electoral commissioner and a private person, I can choose to give testimony in an election petition or not. That is the way I see it, and that's my opinion. And I believe in this particular case, tremendous justice would have been done to the people of this country if the Electoral Commission had simply mounted the box, produced the evidence, convinced everybody in court, including the people of Ghana, that nothing untoward happened in the elections. We would have been better for it than what happened.
If you take the next application that appears to, again, not appears, but actually was dismissed by the court, the application to reopen your case, the court reasoned, among others, that the principles for reopening cases are there. And as lawyers, I think we all know them. And one of them, the key one, being the fact that the basis asking for the reopening should have been founded on a fact or an issue that did not exist and could not have been disclosed by any reasonable search or diligence at the time of the closure of a party's case. And therefore, seeking to reopen a case in respect of a matter that ordinarily could have been dealt with by the exercise of skill or diligence is not one the court will countenance. Do you have a problem with the position of the court in this regard?
I even before the court ruled on that matter or sat on that matter, I had conversation with friends in which I told them that it was going to be a tall order for the courts to rule or allow the petitioner to reopen his case. Because just like you have said, we've all read those principles. The court has said time and again that they will not allow a party to reopen his case unless he can demonstrate that he's come across new evidence which was not available to him after diligent search at the time he was prosecuting his matter. And that is not even that evidence was not available. That evidence should have the propensity to tilt the balance in his favor. So the court not only sees the new evidence, but must evaluate that evidence to see whether it is tangential, it is material, what weight to put on the evidence. And in this case, just thinking like a lawyer, I didn't see how one could successfully convince the court that the Electoral Commission, who had at all times been in court, was not otherwise available after after diligent search. And now that she was available, they should allow her to mount the box. You want to open the case to allow her to mount the box. I didn't also see how the court would, what evidence, because the petitioner had just applied to reopen the case, and I didn't see the evidence that the petitioner was making available to the court to compel the court to exercise its discretion in his favor. And so I had difficulty. I had said that on the balance of probabilities, the weight or the balance tilts against the petitioner, and I didn't see how the petitioner were allowed to reopen his case. So in that case, I just like all lawyers think, I thought that there was going to be a very tall order. But the petitioner did successfully argue, and I was convinced that, and the courts relied on a precedent to rule against him, which precedent had, as this for, the beginning, the preamble statement to the precedent they relied on at the stare decisis, as the stare decisis was that, as the ratio decidendi, that the basis of the decision. The basis of the decision, the they had omitted the preambular statement to the rationale, and the petitioner's lawyer pointed out to them that the preambular statement was actually the rationale, which was in the interest of justice. So the only reason why the court had allowed the reopening of that case, which was cited, the reopening of the case in that case, which was cited, was in the interest of justice. So, well, even though the court did not agree and accept the proposition of the petitioner, I felt that, well, the interest of justice in this election petition overrode whatever considerations that one could have.
At the beginning of the show, you indicated that even though, that people who lose cases in court, of course, are not satisfied or won't be satisfied. But from a legal standpoint, you can't be satisfied with the breadth and depth of judgments, even if you're not happy. Being happy is one thing, and being satisfied is another. So even though you may not be happy, you could be satisfied. Now, on a more from a more evidentiary perspective, and let's take it from there, you came to court, or let's say the NDC came to court, with certain complaints about numbers, with certain complaints about irregularities, and with certain complaints about pardons of figures for some of the parties. Question is, did you have adequate evidence of the standard that would tilt the balance of rights in your favor, for which the court would now be led to a decision in consonance with what you're asking of the court? Or do you think that your evidence fell short, at least measuring by the standards of 2012?
First of all, and the court said it clearly, and the address of the petitioner's counsel also indicated that this petition, election petition 2020, if you want, Henry Mahama and Akufo-Addo, is different.
What is different about it?
It's different from Henry Akufo-Addo and Mahama.
What is the distinction?
Henry Mahama and Akufo-Addo. In the case of Mahama and Akufo-Addo, the contention of the petitioner is simply that on the basis of the declaration by the Electoral Commissioner made on the 9th of December 2020, and the facts upon which the declaration was made cannot be sustained.
The declaration cannot be sustained?
The declaration cannot be sustained.
Was that what you were complaining of in court?
Yes, that's what I summarized. That's the issue 2. The data contained in the declaration of the 9th of December cannot support that declaration. That's just what we were complaining of. So the declaration, the first relief was that that declaration was unlawful, unconstitutional, it's null and void.
And because? Because
that data in grounds 2, which was contained in the declaration of the 9th, could not support that declaration.
Did you show adequate data?
So what was the data you wanted?
Evidence, and did you show adequate evidence to show that?
What data did you want? You didn't need any data apart from the data of the Electoral Commission. You were not arguing, and that is the difference between, in the case of Akufo-Addo and Mahama, the Akufo-Addo and Mahama was challenging the conduct of the elections. The conduct of the elections and the infractions which were recorded during the conduct of the elections. This is different. Here, the Electoral Commission had conducted the elections and made a declaration pursuant to powers given her by the Constitution.
Once the party complained of pardons and irregularities, the party of necessity is speaking to numbers.
Yes.
In 2012,
we were speaking numbers.
Correct. In 2012, there were issues of numbers. In fact, in Ghana today, pink sheet has come to signify numbers of ballot papers. So both cases have at least one fundamental fundamental similarity, And that similarity has to do with the fact that there were complaints of numbers. The difference, though, between 2012 and now, it seems, and if my reading of the court disposition is correct, it seems, is that in 2012, there were some evidence presented to it. The court decided on another principle, and that's why the case may have gone the way it did. In 2020, it doesn't seem we saw numbers. We saw specific evidence with a view to establishing the fact of pardon, the fact of irregularities, the fact of things not adding up, etc. Is that not your position, or is it not your perspective as well, that this time we did not do the statistical computation of things to deal with the issue of numbers, the shortfalls, the overvoting, the undervoting, whatever it is? Don't you think that the issue of evidence, quantum, was missing in this particular case?
The issue of evidence, and I do not fault people who read into the election petition the requirement to produce other evidence other than the evidence that the NDC had which was the declaration of the Electoral Commission. NDC went to court on one basic principle, that if you look at CI 1227 and the procedural requirements in compiling election results from the branch level to the constituency level to the national level, on careful reading of CI 127, one can come to a conclusion that CI 127 admits of zero mistake because of the layers of checks and balances in CI 127. So, if an electoral commissioner, after complying with the procedural requirements of CI 127, makes a mistake, it invites parties to the election to go on an inquiry. Because if you read 127, I will not know where a mistake will occur, unless the mistake was intentional. I will not know how it can occur. Because everything must be recorded in the presence of parties, declared in the case of branch level elections, declared at the branches and recorded and signed.
But the parties know their rights.
Well, it's not about rights.
I'm speaking specifically to the complaint that certain declarations were made in the absence of the NDC.
Well, it's not about rights. I'm not even
and the reason is because the NDC representative, left for whatever reason it was, but they know their rights. Why did they compromise on their rights?
I'm not even talking about rights and duties here, Ophian theory of rights and duties. I'm not talking about that. I'm simply saying that if you read 127 and follow the procedure in 127 religiously, it admits of zero mistake. So when an electoral commission makes a mistakes, it invites scrutiny. It puts people on notice. If you want, people will become suspicious. And that's the situation in which we were led into. Because, Dilawach, you know as well as I do, that we have 7 electoral commissioners. Not so. And so we don't have a sole electoral commissioner. So when the electoral commissioner wrote the statement and published the declaration, you mean that the other commissioners did not have sight of the speech she was to give and the figures she was to read?
It's possible that we can have a case of collective error, isn't it?
No, collective error. So all of them.
That's not possible?
Well, that's possible.
At least there was the magnanimity.
In this case, it was possible.
Well, at least there was the magnanimity of the commission in admitting that there was an error.
Because in this case, it was collective error. Because in this case, I cannot understand how the total votes, and we all know total votes, which includes invalid votes. we do not know how total votes can be substituted for total valid votes. I do not. I can't just think how that can happen.
It is not impossible.
And in
that kind of error.
But and in the same document where you have total votes cast, you have votes attributed to the various parties, various personalities who contested in the 2020 elections. A simple tally of the votes attributed to them will not give you the total votes as was announced by the Electoral Commissioner. So how did this error just occur? I don't know how it occurred. And that put me on inquiry. It put me on notice that something fundamentally wrong had happened.
The fact that...
And that is what the NDC went to court to prove, that the declaration that was made on that day could not have been supported by the facts that she gave, the figures that she gave. It could not have been supported.
But the court was consistent in its enunciation of, or reiteration of the evidentiary principle that you come to court and succeed on your own case, you don't succeed on the weakness.
You fall on your own case, or you succeed on your own case.
Correct. So in this case, and given what you're just saying, that we came to court with a big suspicion. And again, you know that the principle of law is that a multitude of suspicions do not amount to evidence.
Evidence, yes.
So we came, all these principles are there. So we came to court with so much suspicion. We have certain evidence that should give rise to a presumptive fact, but we don't have the other evidence, and we expect that the one who has custody of the evidence should come and speak.
Yes.
That's the principle and the strategy you adopted.
Yes.
It failed.
And it failed, yes, I know it failed.
And not just did it fail, but you ought to have known it would fail.
It failed disastrously.
You ought to have known it would fail, isn't it?
I didn't know that it would fail because I thought that, and I always believed that the requirements of justice will override whatever consideration, and that the public interest in that matter will allow the courts to exercise their discretion in calling the public servant to come and give evidence in court, to cross-examine, to assure everybody in this country who had gone out on the 7th of December to go and cast his vote.
So you wrote on
that his vote was properly accounted for.
You wrote on the back of equity in the face of law. But you know equity follows the law. In other words, justice is equity, i.e., this is the law, but the requirements of justice dictates that a law should be sidestepped. But a law will only be sidestepped if it can clearly be shown that the law violates the Constitution. I'm talking about statutory law. Violates the Constitution. But you won't have the law, you won't have the requirements of justice trumping the law when the law hasn't been changed.
Well, and you know, Dinabuchi, the only reason why we had equity coming out and developing as a separate branch of law was because of the failings of law.
To fill the gaps. To fill the gaps.
To fill the gaps.
But there are no gaps here.
There are gaps.
And the gaps are?
The gaps are that a public servant must at all times serve the public duty. And that if you use law, simpliciter, you might not achieve that purpose.
Do you think the court's decision serves the interest of the country?
It serves whose interest?
Do you think the court's decision serves the interest, the future of the country, so to speak?
Well,
given all that you
first of all, it's a decision of the Supreme Court. And the fundamental principle of the Supreme Court, or the administration of justice by the Supreme Court, is that they can depart from their own ruling.
Right.
So, but for now, that is the decision of the court. That might become, in the future election petition, that might become the precedent. Cases to be cited. And I'm sure it will find space in other election petitions, even if not in this country. But Supreme Court can always depart from that ruling. And you know, Rosa Parks' case in the United States, the number of years it took, even in a whole backyard, Moshe and Virginia, the number of years it took for the court to depart to reverse the decision of the commissioner who had simply gone to divide the land between the two parties without going into the merits of the case. You know how long it took? So the requirements of justice will always follow decisions of the court. And depending on the exigencies of the situation, the courts will find reasons not to apply a precedent if they think that the application of the precedent will not secure the ends of justice.
I know you are not a member of the team, the legal team, but as a central member of the NDC, and you represent a central constituency, Tamale Central.
I'm now not an MP. I simply give up my seat, to relax.
Excellent. That sounds like I wasn't going to say a sensible retirement, but that sounds like a good decision, a good decision in personal interest. So that's so be it. That's great. But let me ask you, even though you're a member of the party's legal team, what do you think was the strategy, the prosecution strategy that was adopted by the NDC in this particular case? And do you think, with some comparative perspective to 2012, do you think that whatever strategy it was that was adopted, that strategy worked before the Supreme Court?
You see, I believe I was not part of the legal team, correct? I did not attend any of their meetings, correct? The strategy team of the legal committee, or let me put it this way, I was not also a member of the strategy team of the legal committee of the party or the petitioner. But as a dispassionate observer of the processes, I think that what I get, the sense I get from the strategy of the petitioner and the lawyers was simply that they had in their custody arsenals that could destroy the credibility of the electoral commissioner if she mounted the works. And their whole case was built around the electoral commissioner mounting the works.
So on hindsight, would that then be a flaw in terms of strategic thinking, knowing that the legal option of a party to choose not to come to the box is an option that is open, and very often, defense counsel or counsel for a party can deliberately refuse to get his client to testify as a way of shielding him or her from the exposures of all kinds of risks on the stand. So do you think that in terms of strategy, it makes a lot of sense to craft your case around a party that may not show up?
So the problem in that strategy is the unknowns were too many. So you could not properly come to a strategic determination of your position with such unknowns. Because number one, the respondent has said that your case disclosed no reasonable cause of action. So that ought to have put the petitioner on notice. That ought to have put the petitioner on notice. Because the respondents were coming from a certain background, a certain standpoint. Okay? And that itself meant that at the close of your case as a petitioner, the respondents could make a submission of no case. And that should have put the petitioner on notice.
So that you should have had an alternative
There should have strategy, been an alternative strategy.
Which is equally strong.
But then that alternative strategy ought to have been contemplated within the time frame that the Supreme Court had clearly stipulated that it was going to dispense with this case. So whatever strategy, or if it was a counter or a backup strategy, that backup strategy ought to have been executed within the context of the time frame allowed by the court. And that put the petitioners in the difficulty. The second thing is that the petitioner relied heavily on the interests of justice. That the interests of justice probably will require that the courts would exercise their discretion in favor of the respondent, of the petitioner. And in this case, the courts did not come to that determination. The courts simply felt that it was important to bring finality to this case in a way that will still ensure that the stability of this country, the work of the Electoral Commission is not, the stability of the country is not compromised. The work of the Electoral Commission is not impugned without any further evidence. And so clearly, I would say yes, building your case around the possibility of the respondent mounting the witness box to put to cross-examination to shatter or destroy her credibility might fail, because you will not know whether the respondent will mount the box or not. And that's what happened.
But listening to you, and that sounds like a very fatal strategy, given the fact that if your main focus is to destroy, undermine, weaken, shatter the credibility of the Electoral Commissioner, that may well have happened, but how would that have advanced the interest of the case, which is fundamentally to prove to the court that the electoral results as announced cannot stand. And the court, as you know, given 2012, the court, which is the same thing the court reiterated in the recent judgment, that you must demonstrate that any irregularity or any flaw in the election can only be disturbed. The electoral results can only be disturbed if that flaw or irregularity has the effect of fundamentally affecting or materially affecting the outcome.
That is the time-tested principle of election petition.
So if your focus is the destruction or shattering of the image of the EC commissioner, how would this deal with a more fundamental thing? Don't you think that there was a case of a distortion and a case of distraction? You guys were distracted. There was no focus on exactly what needed to be done.
First of all, attacking the credibility of a witness in the box simply goes to the evidence of the witness. What weight the court will put on the evidence. So if NDC has successfully attacked the credibility of the electoral commissioner by proving in cross-examination that the declaration of the electoral commissioner could not have been borne out by the results she herself has just announced, and by the collection or summary sheets of at the national level, because all that would have been produced in evidence. What do you think that would have had with the outcome of the elections? It's not, you don't look at credibility as standing alone. You look at credibility and weight in evidence. So if you shatter the credibility of a witness, it affects the weight to give to the evidence of the witness. And so that was a strategy. 2, how are you going, and you know proper custody. We all know proper custody. In this particular case, if you ask me, who is the proper person to produce elections results which can be relied on? Because that's proper custody. And we know proper custody. I mean, so the photocopies or copies of a document are received in evidence when the original cannot be produced or when the copy is certified as a true copy. We all know that in law.
But in this case, the original could not be produced because the
Electoral Commission simply said, I won't produce.
Right. So
it's not that it could not be produced.
Right. No,
it was available.
Well, it could not be produced by you.
No, we could not.
And therefore,
even
isn't it?
Even if it was produced by the NDC, NDC would have been charged with theft. Because they ought not to have custody of the original documents.
With all respect, and I respect your legal positions a great deal, but with the greatest respect, I think that would be a bit overstretching it.
What I'm saying is that
because the documents of the EC are public documents.
They are public documents, but the originals are kept with the Electoral Commission.
Correct, and that's why you have the photocopies.
You have the photocopies. And in this case, it's not that the originals were not available. They were available, but they were not produced.
Could you have tried tendering the photocopies, filing them, and getting an objection, and, at least the legal thing, lawyers try that all the time, you speculate, you try a move, and then you wait and see if the opponent is going to object. If they do object, you fight it. If they don't object, you're lucky. Could you have tried that? I mean, the idea of saying, I'm looking for the original, if I don't find it, that's it. What do you think?
Well, I again, let's come back to the original petition. What were the petitioners looking for? The petitioners were not challenging the credibility of the elections. They were challenging the basis of the declaration on the 9th of December 2020. On the 9th of December 2020. And that declaration itself was captured in a CI, a constitutional instrument number 135. And documents that were produced on that day supporting the declaration so made could not otherwise have supported the declaration if the Electoral Commission were minded to look at the figures upon which she was relying to make the declaration. So they are different. They are not about Tamil Central, Tishigo Central ballot station or polling station, 300 people registered, but the clean sheet records 400 people. It's not like that. You're not talking about that. Okay? You're not talking about the irregularity in the election. You're talking about the declaration
but
of
the
electoral
declaration is the sum total of the component breakdown.
Good.
And so invariably, talking about the declaration is indirectly talking about the sum total, talking about the composite parts, which you may still have challenged. So the point is, if you are challenging the composites, which is the overall, and the overall, you are not making a headway because the one to testify on that is not coming. Could you have still found a way of getting either the court to believe your case or shifting the burden of proof on the other side, which may then compel them to bring her or put her on the stand by at least demonstrating the component bits which are problematic and which could not have led to that overall?
The petitioner demonstrated that.
The component parts?
The petitioner did that.
Every part of
First of all, the petitioner demonstrated that the declaration made on the 9th of December 2020 was an error.
That's the overall.
Yes.
You're still talking about the declaration.
The first respondent admitted to the error. The court copiously referred to the error. The court used the term erroneously declared. The legal question that you and I, the legal issue, is when an election result is erroneously declared, how is it remedied? How is it remedied? The court failed, refused, or neglected to avert its mind to it. How is it remedied? Is it remedied with an unsigned communique from the Electoral Commission? Is it remedied by the Electoral Commission coming to say that I've made a mistake and I've corrected the mistake, but the mistake doesn't affect the overall result? How is it remedied?
How do you think it
should be? For me and you,
how do you think it should be remedied?
As lawyers, is terrifyingly fearful if an Electoral Commission can make a mistake, and we all as citizens of this country admit that that's a mistake, and then the Electoral Commission comes back to correct that mistake. It's terrifyingly fearful.
How do you think?
Because for me and you,
how do you think an error, assuming the error is certified, how do you think that error ought to have been rectified?
That's to put us on an inquiry on how the error first occurred. Because I told you that read CI 127 and you will find zero possibility of errors. Because it's election, it's emotive. Because it's emotive, the Electoral Commission cannot hide under errors. So that is why the law itself doesn't even talk about correction of errors. The law is seeking to ensure that an election conducted for the purposes of determining the leadership of the country at the constituency or national level should not admit of errors.
Since we have total valid votes cast and we have total votes cast, those two realities exist.
Yes.
If they do exist, in the scheme of things human,
yes,
is it not possible that in declaring total valid votes cast, I will actually end up declaring total votes cast?
No, it's not. Because
I want to hear from you. Why
because you know the implication of total valid votes.
Correct. We know things, we still make errors.
Really,
these
errors. In fact,
in respect of things you don't know, we still make errors sometimes. We don't do that.
Maybe I'm limited in my understanding of the conduct, election management, and administration in other countries. But I'm yet to read that an electoral commissioner has made an error.
It's a monumental error, but it's a human error. There's no doubt about the fact that in dealing with errors that can literally cast a spell of civil war in the country, it's a major, there's no doubt about that. There's no doubt about that. Yes. That's a major error that in some countries could have led to violence and chaos. Yes. But it's still a human error. And these declarations are made by humans. So I'm saying, total votes cast, total valid votes. This is a conceivable error that can happen.
That is why we moved away from the champion concept of a sole commissioner to a seven-member.
And we just agreed that the possibility. Don't we have the possibility of collective error? I totally understand. I understand the gravity of what you're saying. It's not if I'm oblivious to it. I understand the gravity of what you're saying. That it's an error that should not happen lightly, but it has happened. It's an error that routinely doesn't happen, but it's human. It does happen. So the argument I'm making, and the point I want you to address, is: are you really certain that it is an impossible error? For which, cause, if it happens, there are fishy things. Or if it happens, it's okay to look at the reasons leading to that, but it's conceivable that it happens. You don't think so?
Because elections are emotive, and it's about leadership, contest for leadership. You know what happens when a party emerges victorious, especially under our 1992 Constitution. Everything should have been done to forestall, prevent, limit the possibilities of error. Now, what further aggravated and heightened the suspicion of the petitioner and members of the party was the fact that there appeared to be a comedy of errors. And that cannot be acceptable. Yes, I agree that these errors are only human. I agree. Only human beings can make those errors. I agree. But as human beings, sensitive and not oblivious to the possibility of the consequences of such error degenerating into civil war and affecting the stability and cohesion of this country, errors of that nature should be the last of it.
I certainly understand your point.
Now, for me,
and thankfully, we didn't have that.
We didn't have that.
Thankfully.
And between you and I understand that we have spoiled ballots. I also understand we have invalid ballots. And then valid ballots. Now, at the counting level, whether branch or constituency, at the branch level, the branch level, parties will have to agree whether a ballot is a spoiled ballot or an invalid ballot. And when that agreement is done and the counting is completed, you can't go back to invalidate ballots that you had said were valid. Because there must be finality, predictability, certainty in the process. And that is what we expected. That a confident electoral commissioner walking to the days to announce or declare the outcome of an election would have checked and cross-checked her figures before doing the declaration. That this mistake was needless, unnecessary, unacceptable, and clearly smacks of some level of incompetence on the part, if it is a collective mistake on the electoral commission, and if it was an individual mistake on the part of the electoral commissioner.
Some have argued that the NDC as a party appears to have a personal problem with the electoral commissioner. Do you think, and from a more objective standpoint, do you think that the petition, together with the strategy adopted in the court, appeared to have created a fixation on the Electoral Commissioner. And that not only undermined your own case, but even moving forward in terms of the relationship with the Commission, things are not rather constructive. What do you say to this?
We do not have a fixation on the Electoral Commissioner. But we are worried about the way the Electoral Commissioner was put in office. Fixations of this nature are not limited to the NDC. I remember when Charlotte Osei was appointed Electoral Commissioner. My good friend, Gabi Wachiridako, was with me on Newsfile. And I won't repeat what he said of Charlotte Osei here. Because it's an election matter, and you are choosing an empire, you will want that empire to be as neutral as possible, because it's going to be an independent assessor, or if you want, aggregator of the results that you will garner in the elections. So that is why Afarijan, at any time that a party was in opposition, Afarijan was not his darling boy, because that is the nature. That's why I have said probably it's time. We've run the Constitution for 25 years.
What, 28?
28 years. It's time for reforms. We have to reform the Electoral Commission. We have to insulate the Electoral Commissioner in such a way that when she makes a declaration, we can all accept that declaration. Yes. And I speak informed by what happens within the American system, where electoral commissioners of the various states appear before Congress to certify those results. And at that point, challenges can be mounted against
you spoke about the nature of the appointments of the Electoral Commissioner, and that's something you're not happy with. What is your concern about her appointment and how she was appointed?
I'm not the first person not to be happy with the nature of the appointment and the procedure for appointing an Electoral Commissioner. This has been part of the grievances of political parties since we went democratic.
So it's not peculiar to...
It's not peculiar
to the current Electoral Commission.
Yes. So we must address...
That's why it becomes instructive, why you appear to be fixated.
No, we're not fixated. I mean, everybody has been fixated. You see, an Electoral Commissioner, and you know from our constitutional law classes that even the appointment of judges attracts a level of fixation until they go through 2 cycles of governmental change. Then you are able to assess whether that person will pander to the dictates of the party that appointed the judge, him or her, or not. There must be a basis for assessing. So, for instance, if Charlotte Osei had stayed in the office till now, the fixation that the MPP had on Charlotte Osei probably could have been dispelled by now on her performance in office. But she was not given that opportunity. So this fixation that we have on the Charlotte Osei is not akin to the NDC alone. It finds its roots long before NDC raised issues about the Electoral Commission. And so for me, if an Electoral Commission is to get that level of credibility and respect like Afarijan did, and now taking it from Afarijan, that Electoral Commission must serve many other governments, must produce results or collect results of elections that clearly show that results manifest the ultimate will of the people. And all political parties will come to accept that if this Electoral Commissioner goes into an election, it will produce the results that clearly were the outcome of the elections. But for the first time in 1992, then the MPP boycotted the elections. They boycotted. Why? They didn't have confidence in the Electoral Commissioner. They didn't. So it's not okay. In 1990, In 2000, they raised hell. Oh, no, in 2004, I think, they raised hell about the appointment of, is it 2004 or 2016? About the appointment of Charlotte Osei when Afarajan went on retirement.
But as a former member of parliament and therefore somewhat of a political retiree now, I'm not sure whether you're retired yet, but I think you're taking a little bit of a backseat for now. What would you say about our evolution, our growth? You mentioned 92. That's nearly 20-something years ago, almost 30 years ago. And then you mentioned the appointment of Charlotte Osei. If we have made mistakes upon mistakes in terms of the appointment process, the reaction of opposition parties to electoral commissioners that are coming, how do we evolve beyond this? Shall we continue the cycle? Because you mentioned the fact that it's normal, and therefore we should just accept it moving forward.
That's why I'm saying there should be reforms, and the reforms should be all over. We've run the Constitution 28 years, you have said. It's time to do some assessment of the Constitution. Is it meeting the reasonable expectations of the people of this country? Is this solving the problems, or is it creating problems? For instance, American jurisprudence. You cannot appoint judges to the Supreme Court unless there is a vacancy. And people watch the nature and kind of judges who are appointed to the Supreme Court. We have an open-ended system in Ghana where you can simply pack the courts. Does it engender confidence in the people of this country?
Have we had any judge appointed without vacancy?
No, judges have been appointed without vacancy. A lot of judges. A lot of judges have been appointed without vacancy. And in fact, realistically, a vacancy will occur if there's a limit to the number of judges to be appointed. So in that case, there's no limit. So there cannot be a vacancy. At any time, there's a vacancy. It's a vacancy. So you can't fault the nature of the Constitution and the fact that there's no limit to the number of judges that can be appointed to the Supreme Court means that at any time there are vacancies.
By convention, the limited number of 13 has been respected for decades.
Oh, but at one point in time, the highest number of judges we had in this country were 9. It came to 10 and 11. This is the only time, for a very long time, that we've had 13 judges. And we haven't seen it yet, at the end yet, because there's no lead, there's no end.
But that's speculative.
That's not speculative.
No, I'm just saying, it's speculative.
Who knows?
It hasn't happened.
Who knows?
Who knows it's speculative?
Who knows?
You are speculating.
But you must speculate on reasonable grounds. There was a basis for
what is the reasonable ground? It hasn't happened.
Because of the open-ended nature of the constitutional provision.
I understand that, but here's the point.
Yes.
Article 11 of the Constitution speaks of the sources of law to include conventions. Yes. Constitutional and statutory conventions.
Yes.
The number of justices we've had in the Supreme Court has conventionally always not exceeded 13.
Yes.
And therefore, I am just asking you from your supposition.
The Canadian case.
I'm not sure how you formed your suspicions that it will exceed. It hasn't exceeded before.
And the Canadian case of conventions. They are as binding as they remain in force.
And so why are you worried then? Exactly so. You have just cemented the argument that there has never been a case where it's been exceeded.
So it has not been exceeded, but doesn't mean that there's no possibility that it can be exceeded.
Correct. But what is the probability it will be exceeded? So far, nothing has been done to indicate it will be exceeded.
Okay.
So we can only hope.
Okay, we can only hope that it will not be exceeded.
The decision of the court has been handed down.
Yeah.
The elections are effectively over.
Yeah.
For all sides.
Yeah.
We must move on with our lives as a country.
Yes.
Governing and governance must continue and probably start in earnest now that things are clear or clearer. Mm-hmm. Tomorrow is the 6th of March. Mm. Is the NDC going to fully participate in the events, especially led by the former president? Is the former president, do you know whether the former president...
Tomorrow is going to be a symbolic celebration of the 6th March at the Jubilee House, I understand. The parade of school girls and boys across the country has been banned, has been stopped because of obvious reasons, COVID-19. I do not know whether an invitation, because it's going to be a ceremony at the Jubilee House, which even though public has a private character, because it will be, you can only participate if you are invited. because the Jubilee House is a security area. So the first question I will ask is whether you are aware that the former president and the NDC have been invited to participate in the celebration, because the Jubilee House is a private area, it's a security area. The fact that they will admit people based on invitation makes that invitation of a different nature.
If he's invited, do you know if he's going to honor it?
I don't know whether he's been invited. And so until I get the understanding that he has been invited, I'll be hard put, actually, in determining whether he will honor it or not.
Is the NDC intent on collaborating with government in the interest of national unity for governance purposes moving on?
Government is always a collaborative action. I mean, wherever you look at democracies strive, mature, achieve on the basis of collaboration, negotiation, and consensus. No democracy has endured by parties to government tearing at each other. That democracy will fail. So, NDC understands the requirement for government and the development of this country, development and progress of this country, will depend on collaboration, negotiation, and consensus. And I have no reason to believe that the NDC and the former president will do anything to show that they are not willing to collaborate to build consensus on how this country must go forward, and also to negotiate on what are the key needs of this country if that invitation is made to them. But the NDC is already in Parliament and it's collaborating. Yesterday I read that a loan has been passed for the bringing in of railways. That's good collaboration. I mean, you simply will ask, oh, why will we be passing laws when yesterday was the day the Supreme Court was going to deliver judgment? Why will we even sit at the table to vet ministerial nominees? That simply is compromise, it's negotiation, and it's consensus. That whatever happens in court, the wheels of governance must turn. And that's why they are collaborating.
Is the former president of Ghana the leader of the NDC at the moment? Is he likely to lead the NDC in 2024?
In 2022, NDC will be at the primaries to determine who leads them into the elections in 2024. I have said, and I will say it again, the former president did one term in office. The Constitution limits a president to 2 terms, even though I have even difficulty in the construction of the Constitution. The Constitution, since even though the word is omitted, it seems to prohibit a presidential candidate from going for a 3rd term after 2 consecutive terms. But, well, we have interpreted that to mean combined 2 terms, whether there was a break or not. So the former president still has that right to put himself up for the leadership of the party for election 2024 and for the leadership of the country in election 2024. And no one can take that right from him. So we only have to wait and see whether he will oblige us by presenting himself. If we do ask him to present himself, we will have to wait and see.
In the scheme of things, is he not the most likely popular candidate in the party at the moment? And so for good strategic reasons, is he not likely to be the one to lead the party in 2024?
Well, they were in 2020, in 2020, before 2018, when we went to the primaries in early 2019, he was the most popular candidate. But he was contested by as many as 6 candidates. And so those candidates who contested him had the right to contest. But the electorates decided that they want to repose their confidence in him and chose him to lead the party. So he must go through that process again we cannot anoint him as the flag bearer. He has to go through that democratic process of being selected as the leader of the party. What I can tell you is simply this. No one can question the commitment of the former president to the peace, unity, and stability of this country. He's invested time, energy, resources into ensuring that Ghana remains united, Ghana remains peaceful, Ghana remains stable. So let's look at what happens going forward.
How will the death of the former president, Jerry Rawlings, impact the fortunes of the party, in 2024, and indeed between now and 2024 and beyond? How will the death of Jerry Rawlings impact dynamics of the NDC, generally speaking?
I'm privileged and fortunate to have worked closely with former President Rawlings when he was in office and the first few years after he left office. I remained one of the people in the NDC who the late president, anytime I met him, could mention my name without asking, just mention my name. The former president, when we lost election 2000, had called us together. We had formed the Youth Forum. This is the Youth Forum that produced Bawa Jamal, myself, Elvis, Haruna, Fifi, Anyidohu, and many others. We had formed the Youth Forum, and the Youth Forum had gone to meet him. And in discussions, the former president has said that it was important to see NDC as a collective property of the people who share in the ideology of the party. And like a company, all of us must have equal share interest, even though some of us will be managers of the company. So former President Rawlings was already open to the idea that the party would survive his death. It was already long before he died.
But he was unhappy with a number of things.
He was unhappy, just like
the time of his death.
Just like I gave the example of a company.
So how,
just like decisions management or some management of companies
can. So how does the party intend, as a testament and as a tribute to his memory, how does the party intend to cleanse itself of the things that the former president was unhappy with at the time he died?
The party's tribute, and we have all, before election 2024, said that the party's tribute to the memory of Jerry John Rawlings is to win back power and continue on the path, the trajectory of probity, accountability, integrity that he set this nation on long before his death.
Okay. Because I'm short of time, let me just ask you my final question. You are in some kind of political retirement at this stage? You are a former member of parliament?
Well,
what are you doing with your life now, and what's your political plan?
My life now, well, I've decided that I want to help feed the nation. I'm doing some farming. I'm doing rice farming. Last year, I harvested a lot of bags of rice. I'm still looking for a market to sell the rice.
A market?
That's the problem. That's the problem with farming. The few years I have spent in farming, even before I decided not to contest again, I was already in farming. And any time that you harvest...
Have you explored the one district, one farm, one factory policy of the government?
I really want to, going forward, I will see how I get myself into the one district, one factory, because where I am, I'm thinking of big things. Elon Musk says, if you're going to do business, you must think big. I'm thinking of big things. And so I might, in future, look at the possibility
of that,
of availing myself with the incentives in the one district, one factory. Now, but I also want, when I was in Parliament, I developed core competences in legislation, and I will, from time to time, be availing myself anytime I'm invited to help them to craft pieces of legislation that the Parliament is looking at. So, and I have just been informed that my rent on my office, law office space is due. So I'm trying to do all three things at a time.
Okay. Well, let me say I wish you good luck with the last one.
But you have not, let me ask you, because the court also seemed to have suggested that in an election petition, there can be a bifurcated process where a party in an election petition as evidence, as part of the evidence to be led in court, alleges that there were administrative and breaches and non-compliance with procedure, of discretionary requirements or non-compliance with discretion, the rules of discretion. The relief will lie with the High Court and not the Court of Appeal. The understanding I have, or the lack of understanding of that position, is the fact that an election petition appears to me to be assessed as a whole and not in that bifurcated manner. Yes, it's true, Article 23 of the Constitution is part of Chapter 5, which Chapter 5 is entitled the Fundamental Human Rights and Freedoms, which vests the High Court with original jurisdiction in such matters. Mm. So I agree. And I've gone to court to argue on that. But for me, if in an election petition, the Apex Court of London is saying that, well, yes, you are alleging administrative breaches, and you are alleging non-compliance with the exercise of discretion, and Cote has said in an earlier case that non-compliance with the or wrong exercise of discretion and non-compliance with the provisions of administrative procedure has remedies at the High Court and not at the Supreme Court. And so that's the wrong forum to have brought the action. But that action...
Unfortunately,
that action is in an election petition.
Right.
That is what, as a dean, probably in the next law class, we'll have to digest that.
Perhaps that is the reason I'm running, because I can see the question is coming. And yes, I have taken note of your question. Unfortunately, I sit in the seat of questions.
Okay.
So I don't have answers.
Okay.
The next time I have the pleasure of sitting in the seat of answers, I will volunteer some answers if I have some opinions to share. But certainly, yes, I take your question seriously, and thank you very much for drawing our attention to that.
Okay.
Now, I will just end by saying that just as the current president, who was then the presidential candidate of the NPP in 2012, the presidential candidate to the NDC demonstrated exemplary leadership when he accepted the decision of the court, even if he doesn't agree with the decision. As a country, we have only one country.
Yes.
And it's a testament to leadership that we have between the two gentlemen who have judicially fought twice, each accepting a loss and allowing the country to move on in the interest of Ghana. Thank you very much. You've been on Town Hall Talk. The program has been sponsored by the Magdan Shipping Company Limited. I wish you the best of the weekend. Thank you.
There's the sports news you know.
A new world record for Usain Bolt.
There's what you're told.
Lionel Messi does it again. It's super.
And then there's what you should be told and how that information should be presented.
From the ANAS video, clearly, it's being used as a vehicle for illegality.
That's where we come in. 2 hours of insightful analysis, the latest news, views, and interviews in one quality, unadulterated content.
Team Talk is live on ASAASE Radio 99.5.
Danger here. Save.
At 11 a.m. on Saturdays.
A well held at the second attempt.
Sunday night in the first Sunday of the International Women's Month brings you a conversation with Frema Akosia Ose Opare, an economist, banker, and a Ghanaian politician. She represented ASAASE West Wuogon constituency in the Parliament of Ghana. She's the current and first female Chief of Staff of Ghana.
I think women, because of the way we are nurtured, have these multi-skills. We can do economic work and balance it up with household work and childcare. Ghanaian woman is actually nurtured to play multiple roles.
Make a date with Frema Opare, Chief of Staff, this Sunday at 7 p.m. with Nana Ya Mensah, with a repeat on Tuesday at 7 p.m.
Wash your hands, sanitize, mask up, and keep your social distance. Abba, be safe, oh. So all of us go fit be safe from corona.
A public service announcement from ASAASE Radio.
There's a sports news you know.
A new world record for Usain Bolt.
There's what you're told.
Lionel Messi does it again. It's super.
And then there's what you should be told and how that information should be presented.
From the ASAASE video, clearly, it's being used as a vehicle for illegality.
That's where we come in. 2 hours of insightful analysis, the latest news, views, and interviews in one quality, unadulterated content.
Team Talk is live on ASAASE Radio 99.5
Danger here. Save.
at 11 a.m. on Saturdays.
A well held at the second attempt.
Sunday night in the first Sunday of the International Women's Month brings you a conversation with Frema Akosia Ose Opare, an economist, banker, and a Ghanaian politician. She represented ASAASE West Wuogon constituency in the Parliament of Ghana. She's the current and first female Chief of Staff of Ghana.
I think women, because of the way we are nurtured, have these multi-skills. We can do economic work and balance it up with household work and childcare. Ghanaian woman is actually nurtured to play multiple roles.
Make a date with Frema Opare, Chief of Staff, this Sunday at 7 p.m. with Nana Ya Mensah, with a repeat on Tuesday at 7 p.m.
Beautiful Minds is on 99.5 ASAASE Radio. Mondays from 8 p.m. is for your psychological well-being. How to get some if you need help. How to keep it if you're losing it. How to manage and enhance a healthy state of mind for psychological well-being. That's Beautiful Minds on 99.5 ASAASE Radio. Mondays from 8 p.m. Beautiful Minds for psychological well-being.
In this COVID period, the mask is a must. Wait!
A public service announcement from ASAASE Radio.
This is ASAASE Radio 99.5 megahertz. Ghana marks 64th independence anniversary today. For the first time in the history of Ghana, last year's Independence Day was held in the Ashanti region, Kumasi. This year is back here in Accra, but not at the Independence Square, but at the Jubilee House, the seat of the government, because of the COVID-19 restrictions. Let's cross over and listen to the president as he delivers a speech on the Independence Day celebration.
And replaced it with our own, the iconic red, gold, green flag with the black star in the center. The mood of citizens of this newly minted state was one of unrestrained excitement and jubilation because of the prospects of what the future held for us. Later that night, at the old Polo Grounds, that vision of what an independent Ghana could be, that is a prosperous, progressive country, which was to be an active player in the affairs of the continent and the world, was eloquently laid bare by our historic first leader, Kwame Nkrumah. The world indeed took notice of us We have the likes of Dr. Martin Luther King, Mrs. Coretta Scott King, Philip Randolph, Adam Clayton Powell, Ralph Bunche and Horace Mann, leaders of the American Civil Rights Movement, as well as U.S. Vice President Richard Nixon, present with us to commemorate the birth of our new nation. We were an example for the rest of Africa to follow. Not surprisingly, much was expected of the poster boy country. On 63 previous occasions, we've usually congregated in our capital of Accra, and recently in other locations around the country, Tamale in 2019, and Kumasi last year, to celebrate our nation's independence. At these annual events, we have sought to express a deep consciousness of love for country and the importance of ensuring that we realize our potential as the Black Star of Africa. Year after year, we commit ourselves to ensuring that we work to lift the standard of living of the Ghanaian and help construct an economy that is capable of creating a society of opportunities for all. It's taken quite some time for us to get there, but I believe there is far more self-confidence among us Ghanaians today than there has been since the very early days of self-government, that we can make it if we work at it. Today, freedom and the cultivation of democratic values are strengthening our determination to bring into being a new Ghana that is neither pawn nor victim of the world order. A testament to the rule of law, respect for individual liberties, human rights, the principles of democratic accountability, and the dictates of social justice has deepened for our common benefit. Nevertheless, we recognize that the biggest challenge confronting us is to be able